The week is planned from today till 14th of October in Bangalore, Mumbai, and Delhi. We commence the India Idea Week today by video messages from Zia Modi, founder and managing partner of AZB and Partners, and Mr. Constantine Parthasid's partner at Three Crowns LLP, which have been posted on the MCI LinkedIn page. We have around 40 different sessions planned for the entire week with the support of national and international law firms, different arbitral institutions, companies, and other arbitral organizations. MCIA is also an ESG-aligned arbitral institution, and you can find the details of the sessions planned today by scanning the QR card behind your ID cards. I would now like to invite Mr. Puneet Garkhel, partner and leader of Forensic Services PwC India, to give the opening remarks. Mr. Garkhel is the leader of the PwC's India's forensic practice and also leads the Global Intelligence and Strategic Threat Verticals and PwC COE for GKYC. He has acted as a trusted advisor for over 24 years and has worked on major multinational complex investigations, white-collar crimes, fraud risk assessments, integrity due diligence, digital forensics, mystery shopping, brand protection, and crisis management assignments. We invite him to deliver the opening remarks.
Thank you, and a very good morning to all of you. It's been a nice drizzling morning in Bangalore this morning, so I think it's a nice weather to be in. In February, I think we all would have read, February 23, that GPT-4, an artificial intelligence model released by Microsoft, backed up by OpenAI, scored a 297 on the bar exam. I think all of us here would know about that, right? And apparently a bar exam is something which is a grueling 2-day test where aspiring attorneys must pass to practice law in the United States. Right, so in fact, GPT-4 was placed in the 90th percentile of the actual test takers, right? So it basically meant it did today. So does this imply that an AI can actually outperform the law school graduates? And what does it get us thinking with the arbitrations, etc., that we will lead in? Right, so I just want to start off with that thought, and that's something that we will try and cover in the next 90 minutes from our esteemed panel who's here, trying to evolve and see what we do. So that's where we are. All the colleagues that I have here as part of the panel are someone who've kind of been there, done that, and are trying to explore this new technology that comes in. I will leave their introduction at a later point of time so we can move on from there. As we've been discussing, expert witnesses have been an integral part of our legal system, especially playing a very significant role in the alternate dispute resolution and solving multiple issues that we face as part of truth and justice today. But in this rapidly changing, the role of expert witness is also evolving and is being redefined as technology advances. Expert witnesses now need to consider the impact of artificial intelligence, data protection, and many other emerging domains in the gathering of evidence and providing substantial testimonies to get the case going. While the onset of the digital age usually simplifies the tasks, these advancements primarily also come with ethical and practical questions that we seek to address today through our discussion of the panel. So what does it primarily mean? How do we ensure integrity? How do we ensure impartiality of the expert witness in the era of AI, right? So much of data has been floated around. So many thought processes are just put in. How do you really put all of them together to say, okay, this makes sense and this doesn't make sense? This defies logic, but the underlying currents provide the same information. How do we address the potential risk of biasness embedded in the AI algorithms that expert witnesses may rely upon? And I think that's a very important question that one will want to kind of get into a little deeper section of that. Also now with the recent DPDP Act, which we call as the Digital Personal Data Protection Act 2023 is an important legislation in the India as well, which will touch lives of individuals and organizations. What we also realized in the past few years is that digitization in India has taken center stage. Practically, we are moving much faster, has considerations which will need to be factored as part of the process of ADR, especially in cases where they deal with sensitive personal or confidential information. Expert witnesses will have to consider all of these, kind of want to, cut short this here and listen from our experts who've come in here today to kind of talk about this. So in today's discussions, we'll dwell on these critical themes, exploring the intersections of expertise, technology, the recent legislations. While you listen to the panel that we have here, I would encourage to ask questions because we all are grappling with multiple thoughts in our mind. What works, what doesn't work, what will imply, what will not imply. And that is where the learnings, etc., will come out. So once again, without taking too much time from an opening address perspective, thank you all. I extend a very warm welcome. Thank you for coming in today. And let's embark on this journey to understand the role of experts in the new era. Thank you, and over to you to kind of get the panelists up here. Thank you.
Thank you, Mr. Garkhel. We are also transcribing the entire India ADR week, and the transcript for the same will be available on the MCI LinkedIn page post the sessions. With this, I would now like to introduce the panelists and invite them on stage for the first session by PwC on exploring the evolving role of expert witnesses in the age of AI and the impact of the Digital Personal Data Protection Act. I would like to invite on stage Ms. Moushumi Vaidya, Executive Director, PwC India, Mr. Darshan Patel, PwC India Partner, Mr. Shai Wade, Partner and Head, International Arbitrations, RPC, and Mr. Karan Joseph, Partner, Dispute Resolution at Shardul Amarchand Mangaldas. And welcome you all, and it's an honor to be having this discussion on exploring the evolving role of AI and DPDP on expert witness. I think it is a topic close to our hearts, and whether we say it or not, I think all of us are thinking on this, thinking on how technology is going to impact us. Excited to have this discussion with the panel. Before we start with our discussion, a quick introduction of our esteemed panel here. We have Shai Wade. Welcome, Shai. Shai Wade is the partner and head of international arbitration at Reynolds Porter Chamberlain. He advises on international arbitration, serving both as counsel and arbitrator in complex and large-scale disputes. Shai has particularly strong experience in cases arising from upstream oil and gas and energy sectors, as well as in joint venture, shareholder, and partnership disputes, and cases involving information technology, telecom, construction, infrastructure, mining, and international sale of goods dispute. He has represented clients from every continent around the world and in disputes concerning a variety of national laws. He is an expert in international investment law, regularly advising clients on the rights and the international treaties. Shai is the co-founder of a leading textbook on LCIA arbitration and serves as counsel and arbitrator under the rules of major arbitration institutions, including ICC, LCIA, UNCITRAL, ICSID, and others. He is also regularly invited to talk publicly on topics relating to international arbitration and teach seminars on dispute resolution. Karan Joseph is a partner in the dispute resolution practice at Shardul Amarchand Mangaldas. His main areas of practice are constitutional law, commercial law, arbitration and technology, and media litigation. He appears before the High Court of Karnataka, commercial and trial courts in Bangalore daily, in addition to appearing before courts and arbitral tribunals in other jurisdictions. An alumnus of the Columbia Law School, Karan is a registered foreign lawyer with the Singapore International Commercial Court and was recently recognized the Indian Business Law Journal as one of the India's Future Legal Leaders 2023. Congratulations, Karan. In addition to his private clients, he also represents central and state government undertakings. He contributes frequently to international and national publications on arbitration and speaks regularly at seminars and conferences. As part of his active pro bono practice, he represents several minor victims of sexual assault in proceedings seeking the termination of their pregnancies. Karan is an adjunct faculty at the National School of Journalism and Public Discourse, where he teaches a postgraduate course on law and media. He is the managing trustee of General K.S. Thimaiya Memorial Trust that holds one of India's longest running annual lecture series. Welcome, Karan, to this panel. Introducing Darshan Patel. Darshan is a partner with the forensic practice at PwC and has over 25 years of experience across practice areas of white-collar crime, disputes and litigation in the India and US. He has assisted clients in dispute advisory and expert witness services, covering international and domestic arbitrations, resolution of post-purchase price acquisition disputes, as well as matters involving the determination of damages. Darshan has assisted clients in various forums, including the ICC London, AAA, and several ad hoc arbitrations in the India and US. So welcome, Darshan, and thank you all for such a wonderful panel. With that, let's start with a very interesting discussion and debate for today. So let's start with you, Shai. Right? So I think, and we were just discussing maybe before, starting this session, and I could very clearly make out, the very clear interest that you have in this topic, of how AI is impacting the whole ADR process. And in terms of that, I would like to have some of your thoughts, right? According to you, how is AI going to impact the whole process of ADR? And what real and practical examples do you think of applications that it will have?
Good morning. So first of all, thank you, organizers of the conference and PwC, for inviting me to participate. This is, or has become in the past few months, a bit of an obsession of mine. And my children say that I go on about AI and the future of our profession too often. So how is it going to impact what we do, and particularly perhaps how is it going to impact how we review evidence and expert evidence? Fundamentally is the short answer. I think we have seen over the life of relatively young lawyers a dramatic change in how we practice law overall. My colleague was mentioning the use of notar uppers in law school. A notar upper, for those of you who were born more recently, is a book which published more recent developments in law than the latest bound law reports. Now that doesn't exist anymore. That is a concept that's gone out of use. And I think that many other things that we were used to as younger lawyers will disappear, including potentially younger lawyers and younger experts might also become relatively superfluous, and eventually also older lawyers and wiser counsel as well. So the impact is going to be, I think, dramatic, and the impact stems from the development of technology which enables imitation of human thinking and deduction processes. So taking a database, understanding it in the human way, even though machines are obviously human, and processing that into human discourse in a way which we as humans are used to, in the way we as humans are used to seeing text and answers produced. And it's going to be difficult for us, particularly in the transitional phase.
Can you hear us well here?
Do I need to speak just closer? I think it's going to be difficult for practitioners of all types in the transitional stage. Maybe check. Maybe this one is better, or maybe I can just shout in the old way. It's going to be difficult for practitioners in the transitional stage to understand how to process information that they're presented with. It's going to be very easy for the next generation of lawyers who are already probably in practice to process and understand the information they're presented with. It's going to be quite difficult for people who, like both of us on the panel, use paper. You can show the paper that you're using to process our thoughts, and it's going to raise issues which we'll discuss, I think, for evidence that we assess as arbitrators, how to appreciate, how to measure, and how to check the evidence that we're presented with by experts, by individual witnesses. It's going to be a very new scenario out there.
Thank you, Shai. I think you've made some very pertinent points, and we have different views here. As Shai mentioned, it's an evolving impact, right, that all of us are grappling and understanding. So maybe Darshan, over to you in terms of, do you see any merits? And now that, Shai mentioned that eventually after a few years, I mean, we really have to evolve, otherwise all of us would not be having this session here. But so what do you think really, are there any merits in use of AI?
I think absolutely yes, but as an expert witness, a couple of things, right? What we are seeing now is a good number of disputes are technology-based or data-driven, right? IP stolen or what have you. And that's where I think we're in a journey of transformation. People are still yet to understand the different nomenclatures. AI, we talk about machine learning. I think, it's a journey, and the tribunal, again, depending on who's on the tribunal and, the skill set there and the others as well. So explaining that portion and then use of all of these, technology-driven solutions, including AI, generative AI, for the purposes of an expert report. It's never going to, I don't believe, and I hope so, until I retire, that, it's not going to replace experts, but absolutely as an aid. And we use some of it as, as part of our discovery process. We use that heavily in terms of how we are able to get to the bottom quickly, identification of some of the key, evidences. That's where we use AI, and I think we will continue to use AI. I think there are some articles and blogs written about use of AI in reports. I think that is far away, but at least in terms of the discovery process, we do use AI, and I see that happening more often.
Thanks, Darshan, and I'm going to come back to you later because I myself have some level of skepticism in terms of the e-discovery and the processes which use AI and, the other aspects that we need to think about it from an ethics, integrity angle, etc. But before that, Karan, jumping back to you, in terms of, you, of course, go to volumes, millions, really useful, right? And where do you see it will rather be a hindrance rather than a use?
Thanks, Moushumi. And before I begin, thank you, PwC, and thank you, MCIA. It's a pleasure to be here. To answer your question, Moushumi, I think it's a function of time, which is what AI does for a lawyer such as myself. Now, obviously, my corporate colleagues use AI way more efficiently, especially to churn out contracts. It works out really quick. I think arbitration lawyers and litigation lawyers such as myself are yet to jump on the bandwagon perhaps as seamlessly as my corporate colleagues have. But to me, it's only the biggest advantage of using AI is to boost productivity, right? Like you said, we deal with volumes of documents, and the United States, where you just end up giving them a room full of documents and say, look for whatever you want. So that's where it helps. In terms of research, I mean, I think we're aware that when it comes to arbitral awards, right, being confidential, the only way you hear about them is if they are challenged, and in setting aside proceedings, there's some information you'll have to cull it out from there. Fortunately, investment awards, for instance, under ICSID, they're all public, right? But there are a frightful number of them. So which is where AI works brilliantly. If you could put in, even let's say in a chat GPT, perhaps the 4 version, right? You put in something and say, look, this is my principle of law. Can you tell me all the ICSID awards on it, right? It's phenomenal. I mean, I understand what Shai was saying in terms of making juniors redundant, but it's way more efficient than I am as well, right? There's no way anyone can go through that much information humanly, right? So that way it's great. You can use it to summarize documents, summarize judgments. Another key area is, I mean, obviously in arbitration, everyone, especially when it comes to a 3-member tribunal, right? Everyone wants to do their research on their nominee arbitrator, right? They want to know, this is my issue. I need to be able to see how, or rather who, is likely to rule in my favor, right? And that's the overwhelming reason why people choose who their arbitrators are. Now, whether those arbitrators, their nominee arbitrators, are actually going to rule in their favor or not is, that's a different issue. But at least, that's the hope. So you've got a bunch of websites that actually tell you, these are the arbitrations that this person has been and sat in, this is the disposition of her or him. So imagine if you can do that quickly without having to spend a day, right? So I think in terms of research, not just on points of law, but also on whom your arbitrator is. And perhaps to a certain extent, again, given confidentiality, this is a little difficult, but also who your witness should be, right? What is their stand likely to be? You can also do, well, apart from that is the regular case management, drafting, all of that. The way I see it, I still settle all drafts that are prepared by my colleagues. So maybe AI will do it a little quicker, but I'll still have to sit there and settle it, at least for now. Maybe once it gets perfect, I may be redundant, but like Darshan said, let's hope it doesn't come to that. But what I do miss, because you alluded to this towards the end of your question, is my fear is that the more reliant we are, I think we may lose creativity, right? I miss brainstorming. I miss speaking, I will miss speaking to people and bouncing ideas off of each other. Because that's not something, at least I think AI is capable of at the moment. So I think we may lose a little bit of the creative process. And to me as a lawyer, that's extremely important.
No, absolutely, Karan, and very valid points there. I'm already thinking in terms of the aspect that you mentioned around the data and the fantastic use it can have in terms of productivity and research. And of course, I think all of us have to acknowledge that one of the key things why the whole ADR process, the importance of that is the speed, the efficiency, right, and all of that. So of course, this goes to the core of its use case. I think some of the questions though that come up are in terms of the data biases, and I think Shai, you alluded to it, right? Because at the end of the day, whether we call it the AI, machine learning, right, or its various different forms, it is based on the data that it has in its repository, right? And the millions of data and analogies that have been fed to it already. So how do you see, that? Do you think it would have any inherent biases, Shai?
So yeah, I do think particularly current versions of AI models and programs do embody and capture the biases that are fed into them. And even the larger language models that are talked about a great deal, that are leading perhaps into general artificial intelligence in the future, they may still capture the biases. Quite famously, I think, or at least it was reported, that Amazon started recruiting using an AI process. But they found that the recruitment process adopted and enhanced biases against ethnic minorities and against women. So they had to abandon that system. Now, that doesn't give those professionals who work in recruitment pause for a sigh of relief, because the next version of the recruitment process will overcome the bias issue. And so, to touch upon Karan's issue of creativity, which you will miss, and I will miss as well, the question we all have to ask is whether the recruitee will miss the creativity of the individual human recruiter before him, and whether our clients will miss the process of creativity that we go through and we enjoy and bill for. And ultimately it touches upon the question of quality, which I think is very relevant also to the issue of experts and any form of expertise. Currently, we believe that our process of creativity and thought process and running ideas by our colleagues is a worthwhile process that brings up the best outcome. But what if there is a system that doesn't need that discussion and discursiveness and comes out with high quality output? In how many of us, other than present company excluded, how many of our competitors are right 90% of the time? In my experience, my opposing counsel is wrong 90% of the time. I'm sure you find the same thing about your opposing experts.
Yeah, absolutely. And so I would think some of these tools and technologies can be used as a bird on the shoulder, right? Where it leads you to a certain path, but when it comes to an expert, I think, given the discussion around, what data has been fed into the model, right? Again, information about the reports of other experts or even the opposing experts are not public, right? To the extent they are, it's helpful. Case laws are there, but specifically as it relates to arbitration, a lot of information is not public information. So where is that data going to, where is the tool going to, you need to give that data to the tool to be able to generate. Having said that, and that's why I kind of like the analogy of bird on the shoulder, one is the lack of creativity, but the other thing is no two cases have similar facts, right? And that's where you'll have to intervene and to say, all right, the base data, fine, review of millions of documents, great. Again, when it's reviewing, you need to give it the sample, right? So it has to be a sample that's worthwhile. The review needs to be, more detailed because it's going to extrapolate the results. But at the end of it, you still need to do, based on what we have as of today, yes, technology will change, but based on what we have today, still like a quality control process, even on the discovery side, and more so when you're doing the analysis and the brainstorming. I think that's where human interference is still needed.
No, absolutely. And, I was just thinking when, a scenario, a hypothetical scenario where, everybody is using the AI and let's say both opponents and counsels are using, and what if you're almost getting, similar analysis, similar arguments? I think that could also be a practically, very difficult position to be in, right? Because at the end of the day, the vast data set that is available to tools at both sides is going to be same. So that's where, of course, the human intelligence is going to play a far more important role.
If I may, sorry, I might be preempting a question, but actually I think the interesting point is if everybody's using the same tool and it's coming out with the same results, then that's a perfect result. For the process, for arbitrators, if I'm sitting and I have two parties and they're advocating the same thing, it's a very short route to an enforceable award. So that's great. The problem is, I think, or a question may arise, it may not be a problem because it's not, we don't have enough experience yet. What if we're using different AI programs and the answers are very different? And then there are lots of problems about current technology, the black box issue, which many people will have heard of. it turns out that the programmers of AI chatbots and models don't really understand how the program generates the answers. And so for experts, you're going to have a problem explaining the answers that your AI has come up with. And so whilst we don't understand the process, we will still probably need lawyers and experts to explain what's happened in the meanwhile. But as the AI improves, then it might be able to explain its methodology as well as just producing a decent output. So we still have some time to enjoy our professions. But the question then is, I think, that follows from different types of programs and different answers is what disclosure level as arbitrator you require from your parties. Do we require an expert to say what AI program they've used, or do we treat AI as a word processing program? It's a question which needs to be answered, and I think there is no answer out there yet.
No, absolutely right. And, just a follow-on on that, Karan, from your perspective, one of the key integral matters of the arbitration process is also, taking on the judgment side, right? And let's say if you put yourself in those shoes, right, and when a case is being held and, AI is being used by the expert as a part of the whole process, right, from your perspective, what will be the level of, confidence, and the questions in terms of the whole, ethics and confidentiality and morality around it? Right, in terms of what will have an impact on the arbitral award.
So, before I answer that, just to go back to what Shai said, I think too much AI, and if it's the same consistent answer or argument that both sides have, will take the fun out of what we do. Right? There is, when I spoke about the creative process, it is a lot of fun. It's something that keeps us going. It's a great adrenaline, shot, so to speak. So if we were to do away with all of that, even if it's unwittingly, I think it would take the fun out of the entire experience. I think there's a reason, though of course for me, for instance, it's not by choice, but which is why a lot of people prefer common law to civil law, because it gives you so much more room to, craft arguments, and I suppose you can be ingenuous, so to speak. In terms of what impact AI may perhaps have on judgments, I'm very uncomfortable if an entire judgment or an award was delivered or passed by AI, right? Because, to me, there's no equity there. There's no justice there. It's very cut and dry. What I would, however, try and how I try and look at it is to perhaps use AI as a tool, right? I remember recently in India, there was a huge outcry, and I'm not sure why there was, because one of the honorable judges, I can't remember from which high court, had used AI to draft a bail order, right? It was a bail judgment. And to be fair to the learned judge, he or she said that I have drafted this using AI, and I think it was ChatGPT that was used to cull out the ingredients or parameters that a petitioner has to comply with or satisfy to be granted bail, right? But there was a huge outcry. I don't see why there was, right? Because the way I see it, you can use that information to cull out exactly what you want, and then you apply your mind, right? So as long as there's that, as long as there's an application of human mind, right, I would say by all means we should use AI, whether it's to draft judgments, draft written arguments, draft awards. But I don't think, or I'd be very uncomfortable leaving a decision or treating a case in a binary fashion of it's either this or that.
No, I think Absolutely, and all of you are echoing a little bit of, the facts and the practical risks, that I think all of us are aware of, and therefore, I think, as rightly you are saying, Karan, it cannot be outsourced, to AI, right? It can be used as a tool, absolutely, efficiently. And I think, therefore, I want to go back as, wearing that skeptic hat, and maybe, Darshan, in your case, in forensic, we deal with manipulated evidence all the time. And, as a part of an expert, right, an independent expert, laying over the facts of the case, right, how do you see the risks of, AI and all this cutting edge technology, impacting the veracity of evidence, if at all?
I think digital evidence plays, a key role in arbitration, but ensuring that that digital evidence has been captured, right, in the appropriate process and protocols have been followed, because we have issues of, generative AI writing emails, right, where actually the individual may not have written the email, and then we rely upon those emails or other evidence that's there as part of our experts' testimony, part of our expert reports, testimony, and even in the case hearings. You've got this larger issue that's coming up in terms of deep fakes and the rest, but more from a, dispute resolution expert witness, it's more the evidence, and that's why the collation, ensuring at no point in time has there been any tampering. I think that is key, because new evidence comes into play. What about the old evidence? And that's where the, put on to weigh some of the evidence that is being produced in the matters.
Absolutely, and I think I would like to take, Shai, your comment as well, and more so on the broader perspective, in the course of, international ADR, are you seeing more and more use of digital data, and that being questioned, or, questions around, how does one see and ensure the veracity of that? Are arbitrators, thinking on those grounds, or it's a bit early?
We are thinking on those grounds already, and I think the enhanced use of non-intelligent computer technology or online technology during the pandemic has already changed people's focus. So online hearings have required us, or at least by choice, many of us, when we see witnesses giving evidence on camera online, there is now a common practice to ask for the camera to show the room where the witness is sitting, to ensure that the witness is on their own, or to perhaps have a representative of opposing counsel in the room, if that's possible. During the pandemic, it wasn't always possible, to ensure that they're not reading from notes that are pre-prepared. So that, I think, has moved us on already to some level of enhanced suspicion or preparedness to the issue of deep fake and the possibility of manipulating evidence through artificial intelligence. And it might be that we are unable to detect that kind of manipulation very easily, at least until we develop greater experience. But there are various thought processes out in the field. The Silicon Valley Center for Mediation and Arbitration have produced a consultation paper on how we might tackle these issues, and have suggested disclosure seems to be their proposal in terms of the use of AI. Of course, that doesn't address the issue of fraud, because fraud, necessarily, if a party is engaging in fraud, they're not going to disclose honestly what they're doing. So it will require greater vigilance from arbitrators in the near term, at least. We've seen, at least from my own personal knowledge through family members, we've seen that there's a move in universities away from assessing coursework towards greater emphasis now on assessing exam work, which is a reversal of a long trend of of allowing students to produce work through a lengthy thought process and research over sitting in a room without the internet and being invigilated as to the evidence they produce. And it might be, at least in the short term, that arbitration takes a bit of a regressive step to ensure that witnesses are giving their own evidence, that experts understand the evidence they produce to the tribunal, and that's assuming, of course, the arbitrators can understand it as well. So we will see a change in practice, I think, I predict.
No, absolutely. I think that's good to know that, the arbitrators and the system is already thinking about it. And Karan, just your thoughts as well in terms of, when you are acting as a counsel, right? And, what would be, the intensity and the propensity with which you would rather try to understand and fact check the evidence that is, provided by the opponent side, right? Because as Shai and Darshan clearly mentioned, there could be an inherent issue in terms of the evidence, which is the basis of the entire case. So are you thinking that people are already thinking in these lines, or we are still being a bit more accepting of the current level of evidence?
I think my job to look carefully at the evidence would be the same irrespective of what's used. In fact, I'd probably be a little more careful if it was, let's say, based on AI or something of the sort. Because as a lawyer, I would be failing in my job and in my duty if I didn't actually, look at it as hard as I would in any other circumstances. And Shai will agree with me that as much as it turns on the law, most cases turn on the evidence that's presented, right? Here's another thing. I mean, what about cross-examination? Right? How do you do that? Right? So that human element is something that you can never replace, right? At least I don't see it being replaced, because evidence by its very inherent nature has to be impeachable, or you should at least try to impeach it, right? If it can't be impeached, then I mean it's good evidence, I know, which doesn't help us again. So yeah, I'd probably treat it the same way, or perhaps marginally look at it a little harder.
And how do you see, the corporates that you work with, seeing, because this is all the lens that, we have as experts, as counsel, as arbitrators. How do you see really, your corporate clients looking at it? Are they embracing the technology? Are they trying it out?
So honestly, I don't know if the experience outside of India is different to that in here. But to my mind, I think at least AI in India is at an extremely nascent stage, especially when it comes to the law. I'm not sure what else they use it for. But when it comes to the law, I think it is at a fairly nascent stage. We are still a society that believes in numbers, right? You've got a bunch of people, especially in our with our corporate clients. They have robust in-house legal teams. They have different layers of checks. So I don't particularly think we're there yet. I think it's evolving. I think everyone's also learning. What's changed really is the suspicion that people have viewed, these processes with. I think that change in mindset, which has been the biggest stumbling block, I think that's changing, right? And once that battle is done, I think we'll see more of it. But, this is an interesting question that I'd like to hear more from Shai in terms of an international perspective, because here, not to my knowledge.
Right. Over to you, Shai.
So, two of our key clients are Google and Meta. Not on the same matters, but they are two key clients of our firm. And yes, they use artificial intelligence. Surprise, surprise. And they are active in making it more commonplace around humanity generally. I don't think I'm breaching any confidentiality, because a BBC report recently publicized that Meta is going to introduce a dispute resolution bot into Facebook, so that users can settle online disputes about. I assume I'm not a common user, but I assume when you're arguing with a friend over the year that a particular episode of Friends came out, the bot will tell you. But once we're used to referring those incredibly important issues to artificial intelligence, then we will become more and more used to relying on it to resolve other disputes as well. And I think that in terms of planning and preparation in business generally, boards will become more and more used to relying on machine output to assist in decision making. And eventually, because humans are lazy, we will rely on it almost exclusively. And this process will either take a very short amount of time or a considerable amount of time. But we are heading down that route already. I just want to think about the point you made about cross-examination and its importance, and I agree that because of the concern over deepfake, cross-examination is going to become more and more important, and face-to-face cross-examination in particular, at least until the technology issue around fraud is resolved. But I have not used it yet, but I have been marketed by a number of AI firms a program that prepares cross-examination questions based on a data set. So you upload your case information, and within less than a minute, you are provided with a set of cross-examination questions. Now, we haven't adopted that in our firm yet, and I presume we will when the market does. And that will be great for our clients because they will pay us less, other than covering the cost of the program we buy. But in terms of admissibility, if the lawyers have that program, then I can only assume that experts will have it as well, and you will use it to prepare your evidence. And then the question arises in jurisdictions where preparation of witnesses is frowned upon or even illegal. Is that a way around that prohibition? Because an expert has the same cross-examination questions as I will have asked, and can prepare directly on them. So, big issues.
Darshan, your thoughts on that? Because this will directly impact, as Shai is directly mentioning.
I think it's a change and it's a transformation that's coming, right? We have to accept and embrace the change. If we just talk about iPhones, iPhone 1, now we're iPhone 15, right? Previously, I say, we all, at least my age, we could at least remember 25 of my contact phone numbers. We didn't need to go to the address book. Now, probably 3 or 5 tops. Right? We just leave it to the phone, you got the address book. So I think, if we take that, identifying what are the risks involved, putting into place controls, right, to mitigate further damage, right, on the dark side, on the fraud side, right, and if we take that as something that's coming, build in controls, building that awareness, I think we will be using it. At least some of us may be using it.
No, I think, that's a fair point. Somewhere all of us know and are embracing that we would be using, the technology, AI, and whether it's newer versions, one way or the other. I think the question is, we all will see in terms of how it evolves and, what is the caution, right, and the various aspects that go around the confidentiality and the creativity, right, and keeping the biases away, etc., that will go through it. But for now, before we move on to the next topic, is it fair to say that at this stage, we still see our existence in the process, the human existence, very important while we embrace, the technology every single day? Would that be a fair statement, or?
Short term.
Short term, at least for the next hour. All right. So with that, I think let's turn to in terms of our next theme, and which is also something that I think for the past whole month, all of us have been discussing in terms of the DPDP Act 2023. And while all of us have seen, in terms of how the international regulations were always there in terms of, the data protection, the rights, the confidentiality, and so on. I think it will be good to understand in terms of, given the evidence is at the core of the arbitration process, and as Karan and Shai rightly mentioned, right, how will the whole process of, the data collection, management, evidence, how will all of that work in light of these, new provisions of DPDP? Maybe we start with you, Karan, from an India perspective.
Excuse me. It's a very new act. It's an exciting act. We've had our arbitration act for years now, and we're still trying to figure out where we stand in terms of courts are still deciding or settling certain issues. Sorry, when it comes to arbitration. So I can't wait to see what positions of law emerge from the DPDP Act. But I don't particularly think it's anything new, right? If you think about it, confidentiality has always been key when it comes to arbitrations. I'm using it in the scope of arbitration. Confidentiality has always been key. I think the 2019 amendment to the Arbitration Act actually codified this further by inserting in section 42A. So what it does, in fact, is actually make it a little more stringent, right? So the concerns I'd see is how do you deal with this data? How do you juxtapose the rights that the DPDP Act gives you, right, with the legal basis? How do you ensure that it's the bare minimum data that's removed? You've got to look at what rights the data subject has. So, for instance, you've got let's assume there is a right to erase, and someone tries to exercise that right. How do you then try and assert that in an arbitration? So I think there's a lot of course, there's an incredible onus or responsibility on tribunals, on institutions, right, to comply with the Act. It imposes tremendous responsibilities on them as data fiduciaries, and let's be honest, they're quite onerous. That's one, and two, the penalty is insane. 250 crore, I think, is the maximum, and of course depends on what sort of breach you commit, but there's a lot in there, right? So I think most institutions, and I'm sure we'll come to this a little later, will come up with some sort of structure to ensure that they are compliant, because the Act specifically, I can't remember the section, probably 18 or something of the sort, which excludes, to my mind or to my reading, arbitral tribunals from certain onerous conditions of the Act.
So, just kind of Karan, to the point that you mentioned that of course it is new and one will have to see in terms of, how it really impacts. I think I would like to learn a bit from the international experience. Shai, what is really that you have seen, because the GDPR and other laws have been there in the international jurisdiction for a while now.
As Karan predicts, we haven't seen a massive change in the world of arbitration, although it was feared. There were considerable concerns and volumes and volumes and hours of presentation work produced in paper and orally on the impact of the GDPR and similar legislation on our lives as humans, machines, individuals, private people, and companies and arbitrators. And the fears were very wide-ranging, in particularly in the context of international arbitration, where various jurisdictions appeared to blanket outlaw the export of personal data from one jurisdiction to the next, and where we as international arbitrators counsel generally carry a breach of GDPR with us wherever we go, and work on cases that either cross jurisdiction, or we take our laptop with us to our holiday to finalize the award, or we work with colleagues in our Singapore office, and one day soon in our Delhi or Bangalore office when that's allowed. So there was a considerable amount of concern, but I think the reality has translated into 2 or 3 things which institutions can do. And I am familiar with the LCIA rules very closely, and the most recent version of those rules introduced section or Article 30A, which was all about the use of personal data. And it requires, or it encourages or requires tribunals to adopt information security measures to ensure that where the issue is a concern, personal information is protected, either jurisdictionally or through agreed mechanisms, which would normally be the approach. And in that regard, stepping aside to the ICC has published a Model Procedural Order 1 provision dealing with personal information. And quite a few tribunals are adopting it. It adds to Procedural Order 1 another few paragraphs, which people generally read very briefly and agree to. And then the LCIA and other institutions, I'm not sure what the MCIA has done, but they will tell us perhaps in a minute. But the LCIA has published a statement on its website about dealing with personal data and information, which is one of the requirements of the English legislation, which used to be European legislation. So some practical measures have been taken into account, and then we also have to think about the legal exceptions. I think consent is an important process which will cover most parties to any particular arbitration, and that will be made express through procedural orders or through submitting to the process. And then there's fair use, and as long as fair use isn't abused by a tribunal, the rights of parties will be protected. And then it's not happened to me in practice yet, but there are third parties who may have issues, and that might arise in the context of witnesses, although generally in most cases witnesses are parties or members of organizations or consent to participate. So there are some legal issues to consider, but in real life it has not arisen too many times.
And that's really good to know, Shai, because I think we in the Indian scenario, and I'm sure Karan and Darshan, are seeing a lot of sort of excitement in terms of the question on whether things are going to change, right? And that is obviously also because this is recent and newer over here, right? So there are corporates who are more aware, but also more skeptical at the same time, especially on the points of consent, and on the point of also in terms of the breach. And I think that's one of the reasons is because of the high impact that it may have. Shai, in international jurisdiction, have you actually seen these like consent, or therefore there becoming a potential data breach, practically, or has it always been more of a question mark in the minds of people?
So the practice I have seen is tribunals adopting wording similar to the ICC's model clause on data protection, and so that resolves that gives cover to the tribunal, and by necessity also to the counsel who are working on the cases. So, but it's a rare case, I think, that we engage in practices that could breach the laws. I mean, how many of us have a case where the picture of a witness or a third party is relevant to a case? I'm sure it arises, but it's very, capturing the picture of a person is unusual, is unnecessary in most cases. It might become relevant in cases involving personal rights or copyrights, but those aren't the majority of cases that we hear, or at least not in my practice. And then the issue of destruction. Destruction of documents may become relevant, but if we follow, at least those of us who are member of law firms, if we follow our law firm's procedures in the relevant jurisdiction, things get kept for a certain amount of years and then archived and then destroyed eventually. That would probably be regarded as fair use under the legislation. And so it's not arisen in practice beyond taking the correct precautions. So, and once you do that, hopefully you're compliant.
No, and that's what I think all of us here surely are on the side of, being compliant. And I think maybe Darshan, your closing thoughts on the aspect, because we do get a lot of these questions on the data discovery side of thing and how DPDP is impacting it.
Sure. So, on the consent side is sorted. Both of you've talked about it. Protection, you've talked about it many a times. You'll have personal data commingled with business data, and the business part is what you need. Not much thought, not much protection has gone in how do we safeguard the personal side of the data, and that's where, it's important that we ensure. So whoever is collecting the data, consultants like us need to ensure that that data, whilst not used for the purpose of which, the arbitration or the, investigation or what have you, but that is protected and not used, and not, only certain people have access to that data, and probably sooner rather than later destroyed because, not needed once the matter is over, getting the consent, informing the individual that this is going to be destroyed. I think some of those protocols are important when collecting a whole host of data that is commingled.
Absolutely true, and I think we can go on and on in terms of all the questions and knowledge that all of the expert panelists have over here. But I think I would like to also ask if there is any specific question that we may have in the audience. Sure.
My name is Sushil Shankar. First of all, I'm happy to know I'm not the only one who's obsessed with AI. So I have two questions. The first one is, even as we all are grappling with the rapid, how to deal with the rapid developments in AI, just yesterday I read about something called AGI, Artificial General Intelligence, where artificial intelligence doesn't depend on just the inputs that have been given to it, but it can actually get knowledge from other domains and give solutions based on cross domains. So I'd like to know your thoughts about this. And a related question, you were talking about, Karan was talking about brainstorming, bouncing ideas of each other. So if something like this AGI is going to be there, you think you might have two AIs bouncing ideas off each other, and so the creativity will still be there. So that was my first question. And I'll let you answer that one first.
So artificial general intelligence is the holy grail of software producers who are engaged in this part of their industry, and it is, I think, also what has caused a great deal of concern amongst some leaders in the profession. I can't remember his name, but there was the gentleman from Google who stepped down recently and published his thoughts about the dangers that involves for humanity generally, and he was. It turns out also at retirement age anyway, or long past retirement age, so maybe he used his normal retirement to make an interesting point. I'm not sure. It is it is, I think, a concern generally and for the legal profession, but I think what we haven't stopped doing, Karan, you said your gut feeling, your gut instinct is that having a machine decide a parole case is problematic, right? And I think most of us have that same gut reaction. But there's some research done in Israel comparing parole decisions, actually. It's published in Maxi Scherer's article in, she refers to it, it isn't published yet, in Arbitration International from about 3 years ago. The crux of it is this. Parole decisions were measured over 5 years between a number of parole judges. Even if you eliminate the differences between different judges, there was one consistent outcome in terms of difference. Decisions taken after lunch were more lenient. Okay? So decisions taken after lunch on people's parole are more lenient. If you if you want to ensure you get parole, come after lunch. It's not, it reminds me of the old saying, if the early bird gets the worm, if you're a worm, sleep in late, right? So it's the same thing on parole. But a good justice system doesn't have that quirk. Now, we would like leniency in criminal cases, with the old adage, better to have 100 criminals on the loose than one innocent person in jail. So as a system, we prefer leniency. But actually what we prefer as a system is consistency of high quality. And so the question we need to ask ourselves is our gut feeling that machine making decisions is bad, is that correct or incorrect? And that is the big question that looms, I think, in terms of general AI, and the creativity question, and then whether it's better to have two machines exchanging views between themselves and arguing a case as between them, or whether in that circumstance one machine will be enough.
If you could consider that creativity also, right?
Sorry?
That could be considered as creativity.
Yes, it could be. Whether it's necessary, if there is a general intelligence ever developed that reads the entire internet or whatever within a week, whether you need a an exchange of views, or is it inherent? Probably it's inherent. I don't know. Do you have a...
Well, my view on that, when I said brainstorming, is it's the process, right? When I'm bouncing ideas off of someone, it's during the process that I'm learning something, or I'm trying to figure out why this is going to work or not going to work. When it comes to two, AGIs, so to speak, having that, discussion or bouncing ideas off of each of them, to my mind, I would only be given the result, right? I'm not sure what the thinking was behind that. So, I mean, is it going to happen? Perhaps, but I'd still miss the human interaction and the process itself and what comes from it.
Okay, I'll keep my second question short. You all referred to bias in AI. So, do you think as time goes by, irrespective of how an AI has been programmed, especially with the new AIs that have access to the internet, do you think that they would be able to self-correct and detect if they have any inherent bias based on a general standard, and then eliminate that bias, so it won't be a problem in the future?
The short answer is I don't know, but because I don't know if it's technically capable of doing that. But I do know that a lot of the bias is based on, well, human input, right? I mean, I think one of the most popular cases, Shai spoke about the Amazon one. The other one, if memory serves, is Apple and the Apple card issued by Goldman Sachs, where certain people were not considered to be creditworthy enough, right? And it had nothing to do with their financial history, right? It had to do with extraneous considerations. So I think bias is also an indication of what the machine is learning right? And that has to do, I think that's just down to human beings.
If I may, I think the answer to your question is yes. It will be corrected. If we've thought of a problem, if we've identified a problem, then as humanity we'll find a way to correct it. So the question is when, not if.
Thank you. Thank you.
Thank you. Any other questions? Yes, Vidya.
I think it's a question more for the lawyers. Does it work? Okay. Yeah, my name is Vidya Rajarao. You talked about AI perhaps obviating counsel and experts. What about tribunals? The fourth arbitrator, so to speak. You have the tribunal secretary, and there's some debate in some arbitrations, international arbitrations, so the tribunal secretary was drafting the award. Isn't it better, one could argue, that it's an AI tool used by the arbitrators under the supervision of the arbitrators, rather than the tribunal secretary who was never appointed as an arbitrator, and we have an award by the AI tool, properly supervised by the arbitrators who are appointed, rather than a situation where you have a tribunal secretary drafting the award? I thought it was for lawyers.
It's the question for the lawyers. We'll start with Karan.
I have views as well. I have too many views.
I'd love to hear all of them.
So I think the general experience with tribunal secretaries, and of course they've been challenged, well, not to death, because there haven't been so many instances, but the common challenge is always that the decision was, given by the tribunal secretary, whether it's an administration of justice issue. This is, like you said, the fourth arbitrator. The award was drafted by the tribunal secretary, and courts have, in a sense, fortunately held that, look, it's fine as long as at the end of it, the tribunal, that is the arbitrators themselves, have actually applied their minds to it. So even if there is a first draft or a close to final draft that's been prepared by a tribunal secretary, as long as there's an independent application of mind by the tribunal, that's okay. And this, of course, in terms of the Indian experience, there's not much on tribunal secretaries, but it goes back to, I think, the first decision was somewhere in the 1960s of the Punjab and Haryana High Court, which said that ministerial functions, right, can be delegated. And that would, in a sense, not really affect the award or the enforceability of it. So yes, I think AI can easily take over the role of tribunal secretaries. I don't see why not. Absolutely.
I think that definitely can, and the law permits it. You're right. The recent Netherlands case in the UCOS matter was one of the challenges you're referring to. There's another English one which I should know because I'm an English lawyer, but I can't remember, from 2011 or thereabouts. Also deciding that as long as the final decision process wasn't delegated, basically everything else can be. Now, institutional arbitration practice varies on this. Again, the LCIA, which I know has published guidance to arbitrators and parties in which there is a protocol which should be adopted where a secretary is appointed, where you inform the parties that a secretary is appointed. The secretary discloses their connections to the case and confirm their independence and impartiality, and the tribunal ought to tell the parties what tasks the secretaries may or may not undertake, or going to or not going to undertake. And there's a guideline as to what level of drafting of awards they ought to do. And I think in the LCA context, they shouldn't be drafting beyond the procedural introduction. Now, that's not a hard and fast rule, it's guidance. And how does that apply over to AI? And again, it boils down to the decision or the question of whether we prefer artificial decision making or not. And the answer will be for the short term, as long as we, as arbitrators, sit down and read what the machine has produced and adopt it in our own independent thought process, that is fine. That is the arbitral procedure. You're paying an individual to apply their mind to a problem and answer it. The issue will arise with regard to human laziness, and this entire room is accepted from this principle, but we all know people who will sign off something that's prepared and not improve it because it takes time and it's adequate. And so if you're presented with a believable award by a machine, and you think to yourself, it's adequate, are you going to read every reference on every footnote? Which is probably why arbitrators shouldn't delegate to their secretaries too much, because you need to engage in that process of reading the evidence, understanding it, giving it the right weight. It's a human process which we are used to, understand, and we trust, even though it has its faults occasionally. We will become used to, I think, machines doing more and more of this for us, and then the question is one of disclosure. In the past 3 weeks, I spoke to an eminent arbitrator who very strongly holds the view that he will not disclose using AI, because I don't disclose using Excel spreadsheets and I don't disclose using Word. This is, by the way, quotes. I'm not saying this sounds in the first. For the transcript, this may sound as if I'm giving my own views. I'm not. But this individual was of the view that it's a tool and he does not need to disclose, he or she do not need to disclose what tools they use in the deliberation of their decisions. I am not 100% persuaded that parties would be happy with that. So I see the logic of that position, but if you were paying an individual to apply their mind and reach an independent decision, you may want that individual to do that. So it's a question which I think humanity will move over to the machine, but it'll take us time. People of my generation hope to retire on our current practices, but people of younger generations may consider retraining.
Could that lead to more arbitrator challenges?
In my opinion, not if you disclose.
If you don't disclose and then you later become aware, of the panel, one of them discloses, the other doesn't, or the tribunal secretary discloses, or enforcement again could be a challenge, couldn't it?
The New York Convention doesn't prohibit the use of machine decision. It's wide enough, the language is inspecific enough to permit the use of, or even just a decision produced by a machine or software. I think in India, your act refers to a person, and that in the context of Indian law, I understand, not an Indian lawyer, and so you'll correct me, you require a human to make the decision. Because AI or a machine cannot have legal personality. So the use of the phrase person makes that. This is my understanding, my reading of the law. It might be wrong, so please check. But there are jurisdictions where people are required, and that was introduced in the context of not allowing companies, sometimes not allowing the appointment of PwC as an arbitrator. There are other places where the appointment of a law firm or a group of people is permitted. So if you are permitting the appointment of a financial institution to adjudicate a claim, why would you not permit a software? So, but I think the short answer is the New York Convention permits it. But of course, there will be challenges as that emerges.
Thank you.
Question at the back, please. Just one. So, two questions here, sir.
Okay. So I'll go with the one. And this one is to you, Shai. Just trying to get you to the other side of the coin. We did talk about, there will be disputes which will be more technology driven. There is the journey of transformation we've all talked about. So we are talking about all those things. And we are also saying that there is going to be a situation where it's going to be imitation of the human thinking. Now, when there is a precedence of the AI taking over the human thinking and there are awards in that direction, what happens when in a situation where it's the other way around, where the human thinking of the AI is not correct, and technically speaking you're arguing on the other side? How do you kind of counter that challenge? Or what methods are we trying to think to counter those kind of challenges right now? Because we are on this side to say, hey, AI will do this is the good thing, these are the areas where it will transform. But what happens when we really come to a situation on the other side? Are we thinking about that?
No, it's all yours.
All mine, okay. So you're right that the question arises of when the assumption of people in the industry and of many who read into it is that AI will eventually reach a stage where it is not wrong. I think that's not a credible proposition to make. There will be always cases which will require second consideration because new factual circumstances will arise. So that's my belief. Obviously, it's difficult to see into the future. So whatever system we continue with as a society in the administration of justice, we will probably need a corrective process. And whether we are inclined to continue to trust humans to undertake that, from my point of view, the answer is obviously we will trust humans, and that is the right answer. But if you apply your mind, trying to think of the next generation and its thinking, or even our thinking, because we don't think the same way we did 5 years ago. So our thinking in 10 years' time, you may be willing, I'll just offer this as a proposition, you may, as a corporate counsel, be willing to pay for a cheap dispute resolution software in your first instance, and if either side is unhappy with the outcome, pay for a more expensive dispute resolution process where the computing is more powerful, the software is better designed, because, I mean, right now it is said, and I don't, okay, I'll just not name names, but it is said that some of the freely available AI programs are open to criticism because they're not very accurate, and a lot of the confidence people have in the future of human decision making is based on freely available software. But it will not come to this as a surprise to anyone if you think of it. If you use paid for software, it's already 3 stages down the line. So you can now pay for much better software, and then your confidence in human decision making suffers a knock when you start doing that. So I think there will always be situations where the software gets it wrong, but it's a question of proportion. At some point, insurance becomes a more viable option to the incorrectness. At some point, you will say, as a society, we accept so much percentage of incorrectness, and insurance will cover it, or there will be a process of. Currently, I mean, humans. This panel is accepted, but humans don't get things right 100% of the time. So we will accept some error.
Thank you. So I think we'll take just 2 more questions, which, one at the table here and one at the table behind. Sir, I think you had raised your hand as well. And of course, we can continue, later on.
Hi, my name is Umakant. I have a question in a slightly different direction. we know the fear of AI, which we are, probably expecting in defense, okay, that, whether the AI will be used in ethical manner or position of AI with expert or lawyer, in a dispute. Do you see that being a challenge, going forward? Because, typically as an expert or when you are, what we are going to use AI to basically to make your evidence robust, right? Sometimes you end up getting some evidence which may not be relevant to this case, but it can be, used against, right? Do you see, if it is not being used ethically or moral responsibility not there, going to be a big challenge, what you are probably expecting in defense, right?
Maybe Darshan, you want to take this question?
So absolutely, using AI for the purposes of helping your case, understanding, right, looking at what is it that the opposing expert has put out, has the opposing expert, he or she, used or maintained consistency in other matters to the extent that information is available in the public domain, right? Using some of that to aid you, right, as an expert to rebut the position, or to a certain extent if there is a hot tubbing. And one of the things that I want to kind of allude to is currently you have expert hot tubbing where experts get together and say, all right, where they are able to see for themselves that the opposing expert has a better position, and so probably I'll have to step down on certain aspects, right? Will AI be able to do that? I don't know. I think it's what AI gives is a definitive decision. If you have two models sit across each other, I don't think that will work. But coming back to your point on, the ethical dilemma, again, what are the boundaries that have been drawn? Where is the information coming in? What is the protection of that information that is being used by the tools to deliver a certain outcome? I think some of those parameters would play a key role in, the final assessment of the ethics in terms of the data that is being produced.
Thank you. I think the gentleman at the behind table had a question. The white one. So I think you had a question.
I think that the capacity to challenge awards under the New York Convention will vary in direct proportion to the extent to which AI is used by the tribunal. In other words, the greater use which is made of AI, the more likely there will be, particularly on ground B, the failure to afford due process. It seems to me that it's of grave risk for a tribunal to embark upon a use of AI to any significant extent without disclosing it. And Shai mentioned the UCOS case, and that was an interesting case because it really foreshadowed what we're seeing today in the realm of AI, but of course it didn't have anything to do with AI. The challenging party in the UCOS case was able to secure a very efficient computer program. It's suspected that the administrative secretary, who also had links with one of the firms in the case, which was a complication that I won't go into, it is suspected that the secretary had been writing a lot of the award. So it obtained, after diligent search, a lot of other material, unrelated material, which had been written by the secretary, and then by means of this program, it compared the stylistic differences, or lack of them as the case may be, and was able to establish that there was a 95% possibility or chance that great swathes of the award had been written by the administrative secretary. And as Shai points out, that wasn't enough to have the award set aside. But I think the great question that's going to arise with the use of AI will be a fascinating one. It will be this question. It will be whether or not present courtroom techniques, and for courtroom I mean arbitration room techniques, for the validation and the accreditation of evidence are going to prove adequate to the task of getting behind AI. As a cross-examiner for many years, I've always wanted to talk to the organ grinder rather than the monkey. And the real danger in the prospect of AI being used by witnesses, your opponent, or by the tribunal is that you can never get at the real source of the question or the matter or thing that you want to challenge. And to the extent to which the use of AI can operate as a shield to deflect the cross-examiner or an interested arbitrator from an ability to get at the real source of a disputed fact, then we're going to have to work out whether or not existing methods that we have, existing rules of evidence, which of course is something one shouldn't speak of in the realm of international arbitration, but rules of evidence which are properly utilised and applied in court cases, I would suggest, are perfectly capable of detracting from, if not wiping out completely, any of the ill consequences of an over-enthusiastic use of AI. But the real question will be, do we presently have the safeguards which can be applied to evidence, submissions, and any of the material with which we're concerned in court to ensure that the outcome is not slanted by the application of information which is derived, let's face it, from an unknown source.
So I think, thank you for that question, and it goes to the source and the data collection. Darshan, maybe over to you, and then Karan, your thoughts on the closing.
No, absolutely, and like Bruce said, right, it's the safeguards that you have throughout the entire process, and it's going to happen. We got to be ready for it. We got to be vigilant. That's and don't want to reiterate some of the topics, but it's coming, so we got to be ready about it.
Well, I agree wholeheartedly. I don't think we have that robust mechanism yet. I think as a society we deal with problems when they come, and now that, well, they're here and they're bound to increase, I'm sure we're going to come up with something. But as it stands today, I don't think there's something specifically that takes care or addresses the concerns.
Could I just, I don't have the microphone. I think one of the best examples as an advocate that I've ever been able to find was one of those Nero Wolfe novels. And there was a wonderful little old lady sitting on a criminal jury, and one of the issues was whether or not the accused person charged with murder in this case was right-handed or left-handed. And she observed him pick up a pencil in the dock and begin writing with his left hand. And there was a very, very strong prosecution case, and this chap was acquitted. And the district attorney sent his flunky around to ask the jury why on earth they acquitted. And the little old lady proudly popped up and said, "Oh, look, I saw this man writing with his left hand, and the evidence was that the murder was a right-handed person." And the prosecutor was aghast, and his astonishment was generated by the fact that the accused person was ambidextrous. So you've got to be very, very careful about the misuse of information.
Oh, absolutely, and I think with that all of us agree that we are already thinking about this very deeply, and we all need to make sure that there is consistency, there is adequacy, guidance, so that all of the process happens in a due and fair manner. So I would like to thank the panel, Karan, Shai, Darshan, and Puneet as well, and MCI for the excellent deliberation. I think we are at early stages, and a lot needs to happen still for us as we evolve through this journey. And thank you for the wonderful audience, for some of the great questions, and I know there are some still open, so we can take those along while the session concludes here. Thank you so much. Thanks.